Welcome back. We're joined now on the program by Professor Dahiru Usman, Islamic law expert, Bayero University, Kano, joining us from our Kano studio. You're welcome to the program, Prof. Let's get right into it. We see what is playing out. Iran, Israel, America on that side, and it's looking more of a religious thing now with some of the pronouncements right now. We understand that there's been some sort of order now given to some Muslims in that area that now is the time for you to defend yourself. So while that is playing out, we also have our own fair share of issues with the United States as well. The U.S. Congress recommending, well, that Sharia law be removed from our laws in a manner of speaking. I've had people say they never got to debate Sharia law before it was put into the Constitution, that you just had President Olusegun Obasanjo signing that Constitution, which he had not seen before, and it has become a law. And a lot of people fear that if Nigeria keeps towing down this path, then we might have bigger trouble on our hands. I wonder how you weigh in on this, seeing what is also playing out between Iran, Israel, the US, but more importantly, our own bit of the story with Sharia law. I really hope Prof can hear me and it's not a delay that is taking too long. But it's important to speak to these issues and get the perspectives now of those who are concerned. So, Prof, I really hope that we get the audio bit sorted so you can hear us properly and give us your perspective. But yes, the U.S. Congress has given a recommendation, submitted it to the White House, a two-page document, spoke to a number of things, partnering with Nigeria and all of that. But one of the bits in the recommendation is about Sharia law. And it's important to feel the pulse of leaders, even legal experts, religious leaders, those in government in northern states that operate Sharia law, to understand your thinking of this one. So, Prof, please confirm you can hear me, or you got my question.
I can hear you. I can hear you.
Okay, please go ahead then.
Well, thank you for having me on the studio. And the takeoff point is to acknowledge the fact that the right to religion is a fundamental human right that has been acknowledged, recognized, and sanctioned by international human rights instruments. Hello, can you hear me?
Oh, absolutely. Please go ahead.
Can you hear me?
Yes, Prof.
Yes.
Go ahead.
The takeoff point, like I said, is to acknowledge and recognize the fact that the right to religion is a fundamental human right that has been recognized, sanctioned by all international human rights instruments, regional instruments, and domestic constitutions. The Sharia implementation in Nigeria did not start with the 1999 Constitution. Even as far back as 1802, and as documented by scholars on Orientalists and writers on African customary systems, have acknowledged the fact that Sharia law has been in existence. In fact, outside the Arabian Peninsula, nowhere was the Sharia applied, including the criminal law of capital offenses like it is applicable in northern Nigeria. Now, the issue of the United States demand for the proscription of Sharia, I think it is a very serious fundamental human rights concern to the Muslims of northern Nigeria or Nigeria in general, because the rights of every human being to religion, like I said, is sanctioned, and the Muslims are not an exception. And in fact, that would in a way interfere with the domestic affairs in Nigeria of regulating religious rights. And even the United States, there are quite a number of Muslims, and that the statistics are showing that one of the fastest growing religion is the religion of Islam, and the United States is very well known of religious freedom. So it is surprising that the United States will be demanding that people who have a belief, people who have a constitutional and fundamental human rights to be guided and to be regulated by their religious laws would have faraway United States coming to dictate that people would have to jettison their constitutional right, their fundamental human rights to religion. I think that demand would never be practicable. As far as the Muslims are alive, as far as Nigerian Muslims are alive, the issue of their right to religion is non-negotiable and cannot be taken away by any system. For even the colonial masters, when they came, they tried hard to take away the Sharia, but they could not do that. So I think it is, in a way, I may say, laughable that the United States would think that the Muslims would drop their religious right over and above the demand of the United States.
All right, Prof, let's look at it two ways. Section 10 talks about the fact that the country is not, it's a secular state by essence. So no states, the federation cannot adopt a religion. I want you to speak to that, whether this is not a contradiction. I know that section 275 up to section 279 talks about the Sharia court and all of that. So I want you to help us understand whether it is not a contradiction that in one breath the Constitution says no state or the federation shall adopt any state religion, yet we're seeing Sharia in our Constitution. That's one question. The second question has to do with the latitude of the Sharia law itself. Now, if the argument is, let's use an example, the Deborah case in Sokoto. What was the issue? They were in a WhatsApp group, and then she made some statement that persons within the Muslim community were not comfortable with, and they considered it blasphemy, and she was killed. And the case was an embarrassment, literally, because of how it was prosecuted. I think that case was left off because of lack of diligent prosecution, because of what was even filed in the first place. People expected murder and all those kind of charges to be filed, but all kinds of things were filed, and it was a bit of an embarrassment. So the second question is the latitude. Should Sharia law have applied to somebody like Deborah, who is not a Muslim?
Well, I cannot hear you.
Should I repeat the question?
I lost. You repeat the question because I didn't get the last part.
The first question was section 10. Talks about the federation or any state will not adopt.
That is well taken.
Okay.
Yes,
the second one was the latitude of the implementation of the Sharia law itself. And I gave an example of Deborah that was killed because of blasphemy. She's a Christian. The Muslim guys in our WhatsApp group were not comfortable with what she said, and they considered it a blasphemy, and they killed her. We can talk about the court case another day. But what I'm saying, should Sharia law have applied to Deborah in this instance? Because the argument is, for some people, it's not the existence of Sharia law, it's the latitude of Sharia law beyond Muslims.
Okay. I lost the audience. I can't hear you.
Prof, go ahead and answer the one you heard first. Answer the one you heard.
Okay, the issue of Section 10 of the 1999 Constitution, I think around 1999-2000, there were a lot of debates when Zamfara State started the re-implementation of the Sharia. Now, you see, the issue of Section 10. Section 10 should not be read in isolation to other provisions of the Constitution. Section 10, quite all right, stated in the substantive provision that that Nigeria, no state or the federation should adopt any religion as a state religion. But that does not mean the argument, my view, and many others hold the view that Nigeria is not a secular country. Now, the take-off point in arguing this is, what is a secular state, and what is when can a state be said to be secular? The ordinary meaning, English meaning of secularism is to be indifferent to religion, indifferent to godly things, and no one can say that Nigeria is not a godly country, because beginning from the preamble of the Constitution, we resolved, as per the preamble of the Constitution, to live as one sovereign country under God. And then the Constitution, like all international human rights instruments under Section 38, sanctions the right to religion, thought, and conscience. You have the right to practice your religion either in public or private. And then going down, like you rightly said, there are religious institutions that have been established by the Constitution, like the Sharia Court of Appeal, like the other aspect of the religion that is in the Constitution. And we know that the practice and the tradition in Nigeria is that the federal government, the state governments, do also sponsor religious pilgrimage, which is a religious thing, which is an indication that that there is a religion, that the government recognizes a religion. And then it is obvious and it is known that any political office holder is asked to swear by the scripture he believes when he is taken out of office and out of allegiance. We have religious holidays that are being observed in Nigeria, and a host of other things that really would tell you that those who argue that Nigeria is secular do not really understand the meaning of being secular. For to be secular is to be unreligious, is to have no business with God or any religious affair. And no one can tell me that Nigeria and Nigerians are secular people who have no business with religion. And there are so many other, even the common law as we apply it, is also not a secular law. It is a religious law because it traces its origin from a religion. The authorities are clear. In the United Kingdom, in 1962, in the appeal cases, there is a Bowman against secular state, where the origin and the connection of the common law, which is largely applicable law in Nigeria based on our common law orientation, is also a religious law. So my argument and my take from the prescriptions and the provisions in the Constitution, it is wrong to call Nigeria a secular state just by looking at the marginal note of Section 10. You know, the content, the substantive provision are that no state or federal government should today wake up and say that the only applicable law is, for example, Sharia law or a Christian law. No state or federal government can do that. That is the intendment of Section 10 of the 1999 Constitution. The marginal note that said secular, I think does not, because throughout the reading of the 1999 Constitution, you would never find anywhere where Nigeria is called or declared to be a secular state. And for you to call a country a secular country, there must be a particular declaration in the Constitution to say that this is a secular country. And for countries that have declared to be Islamic states, it is obvious you find provisions in their own constitution that clearly declare the state to be an Islamic state or a Sharia state. So the implementation of Sharia in Nigeria is not in any way an unconstitutional act. Yes.
Yes. Your debate about the secularist outlook of Nigeria, could be challenged if we looked at the context to which secularism means now, not subject to or bound by religious rule. Not subject to or bound by religious rule. Now, if you consider that Nigeria is a heterogeneous country, I believe the question is to the effect that should other populations who do not derive their faith from Islam, as others in the north do, be subject to Sharia law? And northern Nigeria is as heterogeneous as other parts of Nigeria. I believe that's the question, and specifically in relation to Deborah. So should Sharia law have applied to her? I believe that is the context of the question that you should be addressing.
Well, there are two questions. There are two questions. I'm getting to the case of Deborah. The first question is whether, in the light of Section 10, Sharia implementing states are violating the secular nature of Nigeria. That is the first premise, and that was the first question. Now, to the question with respect to the extent of the application of Sharia law, I think there is a lot of misinformation and ignorance of the existing Sharia criminal framework in the states that are implementing Sharia. There are provisos specifically provided that Sharia law is only to apply to those who profess the Islamic faith. It is only where a non-Muslim has given his written consent to be bound by the Sharia penal code that he is to be tried in accordance with Sharia penal code. And the case of Deborah was never tried in accordance with the Sharia penal code of Sokoto State. You know, the way it operates is that from 2000 to date, in the state that are implementing Sharia, there are two criminal codes. There is the penal code laws of northern Nigeria, which has been domesticated by the states, and that applies to those who are not Muslims. And then there is the Sharia penal code that applies only to the Muslims who profess the Islamic faith. No state, in the light of the provisions of Section 38 of the Constitution, is or can subject a non-Muslim to the application and the dictates of the Sharia penal code. So there is a lot of misinformation about how the Sharia codes are applicable in northern Nigeria. You can check the Sharia penal codes did not in Zamfara State, in Kano State, and the other states that are implementing Sharia did not mandate and make the Sharia codes applicable to all that are resident in the states. So it is wrong for anyone to say that the Sharia penal codes, the Sharia laws are applicable to non-Muslims. And in specific reply to the issue of Deborah, I think the Northern Nigerian Penal Code proscribes and punishes blasphemy. And blasphemy, even under the penal code laws of northern Nigeria, and not to talk of even the Sharia penal code, it is a law that is not to be applied by any Tom and Harry, but it has to be in accordance with criminal trials. Right. The Sharia does not allow jungle justice. Sharia does not condone people taking laws into their hands. And I have examples to give. In the nearby state of Kebbi State, sometimes in 2000, I've forgotten the date, but the law report is there. The case of Inshallah against the state. This is even a Muslim that blasphemed our noble prophet, and then he was extrajudicially killed by some Muslims. They were tried, they were convicted, they appealed up to the Supreme Court, and the Supreme Court confirmed their conviction and sentence to death for killing the person that they claim blasphemed the prophet. Prof, so we should understand that Deborah was never tried in accordance with Sharia code, and Sharia in northern Nigeria is not applicable on all, but only those who profess the Islamic faith and who are not Muslims but have submitted their voluntary written consent. All right, Prof.
So maybe we'll allow you to grab some water, but as we wind down, what you're saying in essence is that the Sharia law actually makes provisions for people who commit murder. And in the case of those who killed Deborah, Sharia law prescribes that they should be killed as well. Is that what you're saying?
Yes, if they are... I've given you an example. The case of Inshallah and State, the case of Inshallah and state is even a Muslim that blasphemed the noble prophet.
I understand. So
They
I'm
took
saying
the laws into their-
for those who killed Deborah, they should also be killed under Sharia law, right?
Yes, if they are tried and found guilty, the law would take its course.
Do you think they should be tried?
Inshallah and state.
Prof, do you think they should be tried?
Of course, our criminal law does not give everybody the license, even if a crime is committed, to take the laws into their hands. That is why the criminal justice is there, and even the Sharia, no offense, even outside blasphemy, no offense is given. People are given a blank check to try people and then extrajudicially kill them.
So why were they not tried? Why were they then defended in court instead? Because they weren't tried under Sharia law for the killings, were they? For the killing of Deborah, were they?
Were not defended? What do you mean by they were not defended?
So what happened was the case was taken to court, and those who killed Deborah were defended in court instead of being tried under the Sharia law for killing Deborah, if you understand what I mean.
You see, the issue of trial and defense is a matter of the legal profession and the legal practice. In fact, you know, under our laws, no one can be tried for capital offense without legal representation. It happened in Kano, the case of Abdul Jabbar, the case of Abul Inyas. There are also cases of blasphemy. They were defended. They were provided lawyers by the Ministry of Justice, and at times they were provided lawyers by the legal aid. So there are so many criminal cases that are going
Prof,
on.
what I'm saying is they were tried under Nigeria's law, but they weren't tried under Sharia law for killing someone, is what I'm... Or do you have evidence against that? Were they tried under Sharia law for killing someone?
You see, if you kill, like I gave you example, the case of Inshallah, and the issue of trial under whatever law is the prerogative of the Attorney General. No one can dictate to the Attorney General of state or the Federation under which law to try. The Attorney General may well try to prosecute them under the penal code laws of northern Nigeria, or he may prosecute them under the Sharia penal code. It's the prerogative of the Attorney General, and in fact, the Attorney General has the powers under the Constitution. No amount of interest involved. In any case, the Attorney General can even enter prosecute, and no one can question his powers to do so. So these are political and constitutional issues that are best answered by the Attorney General as to why they were not tried in accordance with either Sharia penal code law or the penal code. He has the choice.
Well, Prof, clearly this is an ongoing conversation, and it's important to have them so everybody is able to air their opinions and have a greater nation. But we have to thank you so much, Islamic law expert, Bayero University, Kano, Professor Dahiru Usman, joining us from our Kano studio. Thank you for your time.
Thank you for having me.
We'll take a moment now. When we return, we have more for you. Stay with us.